have a special guest for you today. This is Justin Pepperny. He is a white-collar advice. The name of his business is White Collar Advice. He provides advice to white-collar crime defendants about what they can expect in prison. Welcome, Justin.
Thanks for having me.
Justin, I'm so excited to talk to you because we talk so much about the admission scandal for the colleges and people like Felicity Huffman, who we know just pled guilty, and people like Lori Loughlin, who has not yet done so. But we haven't had the opportunity to talk, I have not had the opportunity to talk to you about what this really means for someone like Felicity. So tell us a little bit about what you think that the defendants in this case can expect, those that have pled.
The defendants that have pled guilty can expect to be treated like every other defendant, namely Felicity, for example, who just pled guilty, should begin preparing extensively for her pre-sentence interview. And in that interview, she has to convey that she's pled guilty not because she was caught, but yet she's truly remorseful. She has to identify with victims and carry that message over into an eventual sentencing hearing where she's going to have to persuade a cynical judge why she's worthy of leniency. So I would expect from her guilty plea yesterday till sentencing, you're looking at roughly 6 months. And this will be the most difficult time for her. And it's something that's worth discussing as she waits and wonders how long she'll serve in federal prison.
You know, and you talk about that pre-sentencing interview, but doesn't it in some ways start even sooner? You know, we've seen and many TV stations have compared the way that Felicity has presented herself when walking into the courtroom and going before the judge versus some of the other defendants like Lori Loughlin. Does the judge and do the prosecutors take that into consideration as well? You talked about the true remorse and not just because they were caught. Do you think it's important for these defendants to recognize that they are always on stage, not just when they're preparing that report?
It's a terrific question and something I address repeatedly. A disclosure, I am working with several defendants in this case, and I like to think the approach we're taking is more of the lines of Felicity, of accepting and owning it, not denying and evading. I will say with Lori, regardless of what she does, she's going to be scrutinized. I don't have a problem with her signing autographs. If she didn't sign, they would have said she's stuck up and rude and evasive. She's not going to succeed in that approach. Where she could do a better job of, she can understand the stakeholders in the system. She can understand the cynicism that exists. She can understand that whether she had intent or not, it doesn't necessarily mean that the government cares. They feel she broke the law. They have a narrative that she cheated, took advantage of others. And it's in her interest, unless she wants to serve 4 or 5 years in prison, to better understand that rather than get her head out of the sand like the proverbial ostrich. So if she hasn't done it, I pray she prevails at trial. The odds of prevailing, as you know, are so incredibly low. So either she didn't do it or she's getting advice that is not in her best interest. And as a result, she's making matters worse for those that love and support her. And it's going to lead to a measurably longer prison term than it should have been.
Yeah, I mean, there's a lot to unpack there. You know, I recently wrote a book called The Elegant Warrior, and one of the things I talk about in life is knowing when to settle. And I think that for defendants like Lori Loughlin and others, she's not the only one who has not yet decided to take a plea, but there's sort of this inability to face reality. And you talked about it. I know that you've talked about it in other interviews where you've said that you've got to own what you've done and acknowledge it. Now, you mentioned bad advice, but sometimes there's the opposite situation where the client themselves, the defendant themselves, is getting good advice, but just unwilling to take it because they're not yet ready to acknowledge it. Have you come up with those types of people in your work?
I discussed that recently. I was on the Dr. Phil's podcast, and I said it's easy to bash the lawyers and say the lawyers are giving bad advice. Let me be really clear. There is no doubt that some lawyers in this case are giving ethical, honest advice that is in the interest of their client, which namely is there's a great deal of evidence that will lead to a conviction. There's a great deal of evidence that you are not going to prevail. Our advice is you take a plea agreement. I was one of those defendants who flushed money down the toilet, wouldn't listen to the advice of my excellent lawyers. So it's easy to blame the lawyers as a cop-out if the defendant doesn't get the outcome they want, but you are absolutely correct. Sometimes the defendants are in such denial, so ashamed, that regardless of the advice that they're given, they're going to avoid it. And I know that to be the case with some defendants in the Varsity Blues case.
Yeah, and it's unfortunate because sometimes psychologically it takes time to get out of denial and to accept the reality of these things. But every minute that passes and every other person who makes a plea like Felicity just did, that hurts the remaining defendants, doesn't it?
Well, that's right. It hurts the remaining defendants. It delays the inevitable. I have frequently said that living in denial provides some moments of solace, but longer term, it's a recipe for disaster. I needed someone to drop a bucket of ice on my head and help me understand that I was not going to prevail, that the government, once you're in their crosshairs, emerging unscathed, is nearly impossible. And let me be, I think we send too many people to prison in this country. I wouldn't say to you that every plea agreement the defendant signs is absolutely correct. We have to get it as good as possible and have a defendant openly acknowledge, I don't agree with everything the government has said, but I recognize I made bad decisions. I broke the law. I want to begin accepting responsibility, making amends. And if they can do that, it gets them to what their highest goal is. And what's their highest goal? They don't want to go to prison, or they want the shortest federal prison sentence. So by acknowledging it, even if they don't agree with everything, by beginning to acknowledge it, they move closest to their highest value, freedom. And that's something we continually convey to them and encourage them not to drag this on any longer than is necessary.
And you mentioned something really important there, Justin. You said the loved ones as well, and the freedom of the loved ones is now coming into question.
Yep.
We know, for example, with Lori Loughlin, that the prosecutors are starting to focus on the children. And
Yep.
so, and whether that's a pressuring tactic to force a plea or whether that's a true investigation there, it certainly is a danger that all of the defendants in this case have to consider, isn't it?
Well, it is certainly a tool the U.S. Attorney is using wisely. And families they'll reach out to me, and the conversations have moved from, I was worried about my daughter's reputation, to how this would impact her getting into some college and now graduating. It moves from reputation to freedom. So certainly it's a tool the U.S. Attorney has. I don't think they would be sending these target letters to children unless they had actual evidence that the child might have participated. You will find, in my opinion, having done this for 10 years, having had more than 1,000 clients and serving time in prison, that as a result of that the target letter being sent, it will certainly compel some defendants who might have been compelled to go to trial. I suspect it will compel many to plead guilty, if only to ensure their child stays out of prison. And it's also a scapegoat. It's also a tool that they can use to say I was going to go to trial, I would have prevailed, but I took one for the team because I didn't want this to impact anyone in my family. So some defendants actually see it as an excuse to plead guilty, and so it's an interesting dynamic. I've certainly heard quite a bit of that strategy.
Yeah, and that makes sense. If you want to protect your ego and this idea that you've had all along that you didn't want to plead, now all of a sudden you have a reason to do so. Let's talk a little bit about what someone can expect. Now, I have heard talk that Felicity perhaps might not spend any time in jail because her offense was lesser than some of the other defendants in that she didn't pay to have the kid get into school, but rather to change an SAT score, and her level of remorse, and the fact that she pled relatively early. But I would expect that at least some of these defendants will face prison time. If they do, what should they expect, and let's start with what should they be preparing for before they go?
Well, I would agree that Felicity may not go to prison. I certainly don't think she needs to go to prison, and I commend her approach to preparing and taking ownership of it. With respect to preparing for prison, there's a number of things defendants need to do. They need to speak openly in that pre-sentence interview because that will heavily impact what their life is like on the inside, the bunk they have, the job, programs they can qualify for. In some of the cases, the sentences could approach 2, 3, or 4 years. Do they have history of substance abuse, alcohol, or drugs that they can disclose? If so, they can qualify for early release through a drug rehab program. So I believe prison is in the future for most of them. For that reason, they should begin to understand life on the inside, what steps they can take to prepare for early release. If they're going to go to the halfway house, what type of job they should have lined up in the halfway house. If they don't have the right job, I can tell you from experience, prison is easier than the halfway house if you don't have the right job lined up. So they need to begin to understand, what facility should I go to? What programs can I participate in? Massive prison reform was passed in late December, the First Step Act. My colleague Sean Hopwood, who's a professor at Georgetown, worked on the law. How does the first step influence them at sentencing and in prison? So it's really, as Judge Benita Pearson told me on stage last year when we spoke together, she said, Justin, preparing for sentencing is a full-time job. Defendants should leave my courtroom exhausted. If the defendants in this Varsity Blues case are going to get the best outcome, They need to be preparing all day, every day through their own efforts and not just outsourcing all of the work to their highly skilled lawyers.
Yeah, you make some great points, and points that I don't think everyone would anticipate. And someone like you could certainly be helpful in seeing where these, because I think that for especially people like this who probably don't know a lot of people who have been in the prison system and have not been exposed to the prison system, they probably don't even know where to begin. And then there's this just the most basic fear questions. Am I going to have access to a phone to call my family? Sure. Am I going to have access to email and internet? Am I going to have access to the bathroom? Those types of things. What are the answers to that for defendants like this?
I will acknowledge most of the initial questions have to do with prison, and I address them and I answer them, and I remind them there is as much violence in a federal prison as there is in a corporate office park or your local coffee shop. I tell them if you act like a fool in your community, a fight could break out. No different in prison. So I debunk many of the concerns they have about violence in prison. They are so used to, they've seen prison on TV, sensationalized with violence and Cool Hand Luke and Shawshank Redemption. Once I dispel the concerns they have, I then get them focused on what's the most important. Yes, the showers can be uncomfortable at first, get over it. Yes, the guards can be disrespectful at first, get over it. Maybe the mattress is a little hard, get over it. There are aspects to confinement that are uncomfortable. Once we address those concerns, I begin asking the right questions. How do we want to emerge from this experience? What type of legacy do you want to leave for your children? Do you want to show that you can turn struggle and failure into an opportunity to help them? And I remind them, I'm not a motivational speaker here. It's easier said than done. I remind them that they're going to be in prison at some point, and they're going to remember a conversation we had that says, I want to emerge stronger and better, and they're going to have a choice. Can they spend their days in the inevitable boredom of a federal prison, which is the highest value in prison, by the way, not violence, but boredom, or are they going to use their time productively, making their family proud, developing new skills? In this Varsity Blues case, as I wrap up my long shtick here, some of them have had life experiences that their fellow prisoners can only dream. It's okay to share those experiences, to teach, to advise, to mentor. If they can do that, their federal prison sentence will feel like a blip. They'll have found meaning through the experience, and it will not come to define their life. And that is what I wish for all of them. It can be a great experience if they're open to it.
You know, it's such a good point, and I've talked to people who have been diagnosed with illness or faced other tragedies in their life, and many people say that sometimes the thing that you think is going to be the worst thing that ever could happen to you can ultimately be a good thing. And Justin, it certainly seems like you have made the most out of your experience there. Thank you so much for coming on and for sharing your experience. I know we'll want you back here at the Law and Crime Network as this continues, and I hope to see you again.
Thank you for the invitation.
Thanks, Justin.